the doctrine of nurum crimen sine lege, that you shall not be charged of an offense if the offense itself was not known in law. And the argument that the offense is not in law is due to the fact of the jurisprudence that has emerged following the enactment of the new constitution vis-a-vis section 7 of the 6th schedule. That had it been to be brought to conformity to that provision, this offense would not be existing in our books of law. If we had a proactive parliament, and not a parliament like the one that we currently have, this perhaps would have ceased being good law in our books. But granted the circumstances that Parliament itself has not amended this provision, that Parliament is too lazy to bring it into conformity with the provisions of Section 7, are we left helpless? Is it therefore that the DPP has the liberty to charge any other person just because Parliament has become negligent? Parliament has refused to legislate? You are called upon by Section 8 to rise up to the occasion in the event there is ineptness on one part of state organs. And besides that, I may invite my learned friend, Mr. Kihara. Article 10 places you on the same pedestal with the Parliament. Because this court and Parliament is bound up by that provision. So where there is ineptness and negligence on the part of Parliament, the court of law can rise up. In any case, the application of Section 7 vis-a-vis Section 8 of Section 7 to the 6th schedule, vis-a-vis Section 8 of the Magistrates Court Act, can only be applied by this court, not Parliament. So we invite you, Your Honor, to find that there is no offense that has been disclosed by this particular charge sheet. The same is meant to achieve ulterior motives other than that which is contemplated to protect public interest. It is meant to preserve personal egos. It is meant to preserve at a certain equilibrium for which you do not understand personal emotions. Unfortunately, this is a court of law. If anyone feels injured by these particular statements, the recourse is not before you. The recourse is not to criminalize utterances that are constitutionally protected. When you retire, you look at Article 19, 20, 21, and 27 of the Constitution. I invite my next speaker.
Those provisions, the last those articles?
Yes, Article 10, Article 19, Article 20, 21, and 27. And finally, Article 33. But also, look at Section 89 of the CPC, when a court can decline to admit a charge. Allow me just to read it as I invite